volume of personal information created and captured. Social networks, mobile devices, cars, security cameras, even thermostats and kitchen appliances. Collect and aggregate data from and about users, often without their express permission. So how can companies leverage these rapidly growing mountains of information without getting into trouble with users and regulators? So we've got a stellar panel here to answer some of these questions, and I'd like to ask them to introduce themselves very briefly so we can get underway. Please, Mark.
Thanks, Chris. Mark Melodia with Reed Smith. I'm a class action defense litigator, and this is the last time you would like to talk to me. You'd much prefer to talk to my colleagues who can help you on the front end. I co-head our global data security, privacy, and management practice along with Cynthia. And I try to feed back to Cynthia and our team from the front lines, from the courtrooms, the lessons learned, the what not to do's, the things that some of our clients may have had a problem with that we can teach to other of our clients to try to keep you out of trouble.
Cynthia.
Cynthia O'Donoghue. As Mark said, I co-head the data security and privacy group. With Mark, my remit is essentially rest of world. I'm out of our London office, so I do everything but the United States. And I'm on the front end, so I'm helping clients essentially with compliance, develop product solutions in a way that that we can get around the regulations so that they don't act as a stopgap.
I just have to make a quick point about Cynthia. Sitting here, I was very impressed by her enthusiasm for the security aspects of data. I was so impressed. I don't know if you noticed when she walked up, she had padlocks on her shoes. Sorry about that. Rebecca, please, would you?
Hi, good morning. I'm Becky Keene. I'm Senior Regulatory Counsel at CoreLogic, which is an information company. Before I started with CoreLogic about a year ago, I had spent 5 years at the Federal Trade Commission in the Division of Privacy and Identity Protection, and worked a lot on the big privacy initiatives that the FTC has been focused on.
Terrific. And Chris Sundermeyer.
Chris Sundermeyer. I'm the General Counsel and Chief Privacy Officer of Reputation.com, which is a company which is commercially in the business of helping people deal with their online presence, whether that's the form of reputation or privacy issues. I joined Reputation.com several months ago after being a litigator at the Cooley firm for about 20 years. I guess I was there 15 years and a few years, some of us before that. So I have a different perspective than I think a lot of privacy officers, having spent most of my time in the courts dealing with litigation.
Okay, so, but if anybody has a question, please ask us at any time. Stick your hand up, a microphone will come to you. It's all about helping you understand what's going on, so please ask questions at any time. And in fact, we'd like to respond to the question that was asked earlier in the other panels. And Mark, I know you had a thought about that.
Yeah, I thought that was a great question, and I've been a little frustrated, as you seem to be as well, that the market doesn't seem to have appreciated privacy as a value and hasn't at least placed value on that. I think eventually what we'll find is that privacy will be like being green in the market, something that is considered valuable and then eventually expected. We're not there yet, but if you think about it, the average room of 100 people is not this room. This is an exceptional room of people who have a feel for what's going on and what it means for you personally. This is just starting now to filter into true mainstream consciousness. And I think the business community won't appreciate privacy fully until their customers, appreciate it and start to pressure them. At that point, I think there will be a value placed on privacy as at least one of the things that companies are expected to deliver, and a differentiator potentially for one customer versus another, one healthcare company, one financial company versus another.
Okay. Anybody else want to comment on this?
I was going to say, I think it's there already in the B2B, where downstream suppliers are essentially using certain privacy certifications as a kite mark. And so it's basically saying, trust us, we're a trusted supplier. I agree with Mark, we're not seeing it in a B2C situation as of yet. I think it's in its infancy. But I think the existing regulatory environment is problematic for that, and especially problematic in the big data atmosphere where you're essentially aggregating data from lots of different sources, including things that are in the public domain that are not part of a bilateral relationship, which is what the current regulatory situation is focused on.
Okay.
I thought I'd throw one comment out there. An example was used earlier as a success story in mining big data was the Harrahs Casino. I mean, we all would like to think when we go into the casino that we're going to get better treatment, they're going to know about us, they're going to make sure that we have everything that makes us a comforting, fun stay. On the other hand, the catchphrase for Vegas is, what happens in Vegas stays in Vegas. And so I think that's really the tension we have here, is people on some level are okay with data being used as long as it stays where it belongs. And I think the problem is using data in ways in which it's out of context from when people have given you consent to use the data, and that becomes a problem. If Harrah's information gets out someplace else, out of Vegas, that's a problem for people.
And that was a point I noted on the first panel. Somebody said, well, people will trade privacy for a good deal. Well, they're going to trade it for that good deal, but I don't necessarily know that they are trading it for their data to then be sold and then aggregated and resold. And that's where I think the regulatory interest comes in.
Right, okay. Just going back so we can clarify a little bit here. Chris, Reputation.com's customers are typically consumers. So maybe you can help us draw that line a bit more finely as to what is reasonable and appropriate use of their information and where they find it difficult to cross that line.
Well, I think the point being made by Mark that the consumers are now figuring out how much their data is being collected and how much their data is being used only now. So we're all ahead of them in understanding just how much data there is out there that's being collected and just how much is being used. And I think when we see people, it's when they have that aha moment. Something happens in their life where they realize that the capturing of their data and the use of their data is being done in a way that does not agree with their sentiments. And at that point, they realize they need privacy protection or they need some kind of reputation protection. And so I don't know if there's a fine line yet. I think what there is a, in some sense, a group of people who will generally click on every consent button. They'll allow you to use their data. You can't get an app on the phone. You can't sign up for a new service without signing onerous terms of use, which give people broad rights to their consent. And everybody doesn't read those, and everybody clicks yes to the consent. And then they see their data being used in a way that is either out of context or in their mind, the data's not in Vegas anymore. And they come to us to look for some ability to protect themselves.
So Mark, do you have any comments on regard to that from your side?
Well, I think that's right. It's about expectations, I think is what we're saying. And determining where consumer expectations reside at any given moment is difficult. And it's not the same. It's a subjective test. And that's really the problem for the regulator. It's the problem for the judge looking at a case. And it's the problem ultimately for industry trying to decide when the so-called ick factor kicks in. When is the gag reflex of the public initiated? And I do agree, Chris, that I think it's a pretty recent phenomenon that people are paying attention to what is being collected. I trace it to the Facebook IPO. It seemed to me in the spring and summer, there were a series of articles talking about what is Facebook worth? Where should it come out? And a lot of those articles, which were in the mainstream press for the first time, started to talk about how does Facebook make money? And people started to realize, and they started to put dollar figures on the value of each Facebook user's experience and data for Facebook. There's a certain dollar figure, and the market and analysts were looking at that dollar figure, and that was being reported and discussed in the press. It seemed to me that that series of articles and that media attention correlated to what we see in the litigation market, if you will, in the regulatory attention around these issues and public awareness.
Okay. So, Becky, you worked as an enforcement lawyer at the FTC, and the federal government primary regulator for big data, and you're now following their pronouncements. What are the things the FTC has said and done that you feel are most meaningful to big data?
Well, obviously paying attention to what really concerns them, because they believe, the FTC believes it's a reflection of what consumer sentiment is, or where consumer sentiment would be if they really knew what was going on. So they're focused on data brokers. That was a big part of their privacy report. Who are these companies? Do consumers know who they are? Do they know if they have any choices with respect to their data? How can they control what information is being used about them? Do they have any choices when things are wrong? So, for example, you get onto a big data list that says you're a gun aficionado and you're not. And now you're starting to get advertisements, and things like that, and offers that are suited for someone else, not you. And so do you have any ability to sort of control your destiny and what offers you're going to be getting and what information you're going to be getting? Mobile is huge. There is a lot of activity in the government focused on mobile with privacy considerations. How do you obtain consent? That little box you click through that has the 5 pages of terms and conditions that you don't read. How do you communicate to a consumer in a very simple way what choices, what's happening with their data and what choices they may or may not have with respect to it. So, data brokers and mobile are both, I think, a big convergence right now.
Okay. Anybody else any comment on that one?
Well, just to the point of putting disclosures in plain language, it's to the point now where we actually work with a plain language PhD. Yes, there are PhDs in how to write clearly. And and lawyers, aren't even in elementary school on that issue. So we've recognized that weakness and sought help. And so when we go to write privacy policies, we want to be able to walk into the FTC and say, this was really aimed at an 8th or 9th grade reading level.
This is scary. I read an article yesterday about the IRS, which is also supposed to produce policies and directions in plain English. They're having to employ plain English PhDs to interpret the plain English. This is scary stuff. Anyway, Cynthia, you just attended the World Economic Forum's Big Data Conference in Brussels. I think, Chris, you were there as well. Any lessons learned from that that you can share with the audience? Because things are different in other parts of the world, aren't they?
Things are very different in other parts of the world. I suppose by laying the foundation first, the US obviously starts from a consumer protection point of view. The viewpoint in Europe especially, and most of the rest of the world, is that this is a human right and a dignity issue, and it's about trust, and it's not just about protecting consumers. So it permeates not just B2C, but also B2B relationships. And the current framework for privacy legislation and data protection is about 30 years old, starting with the OECD framework. The European laws have been in place for about 20-odd years. But there's a recognition that it's no longer fit for purpose, given the way technology has moved on. However, the paradigm, even though it's shifted, is quite difficult I think in the context, Chris can add to this as well, whereas people are still thinking in that bilateral relationship way. They're still thinking about consent and transparency. They're talking about individuals having more control, but that doesn't address kind of the network or Internet of Things of machines that Splunk is doing. It doesn't address the sensors that are in cars that help with health and safety issues. It doesn't address sensors that are in medical devices that allow real-time patient monitoring, and it doesn't it doesn't address the aggregation of data that can then go into relational correlation for analysis. And so there's still discussion around principles, there's still discussion around evidence base, but I don't think the current regulatory thinking is there yet. It's still, I think, stuck and some of the existing mindset around the current principles. I mean, to give an example of things that actually don't work, I mean, consent doesn't really work any longer. A bar of transferring data because a country doesn't have similar laws to that in the European Union doesn't work. But yet those same principles are still being discussed as part of the change to the regulatory framework.
Yeah, I think the thing that struck me about the conference, and it was attended by a number of people who were from industry, from the insurance industry, from the healthcare, from telecommunications, from some of the large data technical companies, as well as European regulators and people who are activists in the issuance of privacy. And one of the things that really came out through the whole thing is there's just a lot of lack of clarity about what to do and how to approach it. The recognition is that the old scheme does not work. The understanding is that there is this potential out there which cannot be tapped until there's some kind of predictability and clarity, so people realize that they can use their data without taking on enormous liability. And yet the contextual nature of which consent is given makes people realize that sort of a pure consent-based system doesn't work, and there's got to be some other approach. And I think there's a lot of grappling still with what's the right approach.
So what does this mean for a company that's perhaps been operating in the US and now wants to go global? What are the implications for that company if they're looking to gather data or utilize data?
Well, they're two very different regulatory regimes.
Okay.
For one, U.S. has taken a sectoral approach, so it's focused on financial services, healthcare, and of course consumer protection, deceptive practices. Because the European viewpoint is that it is a human right and it's about dignity. It permeates everything, and there is, like you said to the other shoes, a bit of a lockdown. Without going into a sales speech, one of the things that we try and do is provide as holistic a solution as possible. So companies can operate in a vanilla way globally. It's hard to do, and there has to be some sympathetic bent towards the way the laws are in the United States, and there's usually certain protocols, procedures, and things that we have to put in place. But as one of the regulators said at the World Economic Forum from the European Union, the data protection framework is about flow of data, even though it doesn't look like it. And so, that's what we spend most of our time doing, is helping companies gather that data and monetize it and do it in a way that meets that framework. I saw a question.
Yeah, my question is really right on this topic here. It's about Article 29 in the EU. So if you're a US-based company who has apps in the App Store and the Android marketplace, you don't necessarily have control over where they're downloaded. In fact, you may not want to have that control. So what's the starting point for a US company that knows, because we have big data, that EU systems, Article 29 citizens, have data in our system?
Yeah, the way we do it, technically if a website is focused at the EU, so it's a mobile app for EU users only, we counsel companies that they should comply with the European regulations.
What if it's a general purpose app?
If it's a general purpose app,
that we don't know who's using it, and we do know, but
that's marketed globally.
It's anywhere in the world.
Then what we use is essentially a principle which is called country of origin. It's not directly on point. There's no real case law in Europe to guide on this. So basically, US company operating US website, marketing mobile apps from the US, you're subject to US law. So what we do is we take the procedures, the policies and things, and put information in there that European citizens would expect to see, but ultimately still operated under US laws. Now the Asia-Pac countries are different again. Asia-Pac countries have followed more of the original OECD guidelines. So we can kind of get away with that a bit more easily in Asia than we can in Europe. But unless you're in a really high target sector, you're in healthcare, for instance, you're in social media, for instance, that's essentially the way we've been counseling our clients, and so far so good.
And what if you have servers that are actually located in the EU? Does that make a difference in how you look at that?
It makes a difference in relation to the transfer issue, but it doesn't make a difference in relation to the consent and transparency issue. But I have to admit, servers, no matter where they're located in the world, is not really an issue. There's ways around that. There's ways to legalize transfers. It just means, the solution ends up being a bit more costly, but there's no reason not to do something just because you don't have servers in Europe.
There's a question down here.
Yeah. This is an emerging issue. How much contingent liability are you starting to see around this, where it's not maybe the immediate party, but the secondary party that's the bad actor to this, and then there's a contingent liability associated back to the immediate party that was the person that didn't by nature do anything wrong, but
Yeah, that's a contractual issue for the most part.
Do you see a lot of activity in it, though, or is it, because at the end of the day, money drives behavior,
Absolutely.
right? And until that becomes a big enough problem, people are going to be less sensitive to it.
Yeah. Now, what we're seeing, and I'm sure Mark is going to second me on this one, what we're seeing is more of a growth in cyber insurance. Because the contractual relationships, the liabilities are usually quite limited, especially if you're talking about cloud, co-location, anything like that.
Yeah.
A supplier is never going to insure somebody who's has primary regulatory responsibility anyway, and there's no reason why they should. So that's what we're seeing is more of a growth market in cyber insurance.
That insurance market is really maturing, and there's a lot more data around metrics around, who's paying out and what exclusions are they invoking and sort of what those policies are really worth. So we've actually found ourselves counseling clients how to go to that market, and if it's a big enough client, even helping them write policies and then shop that policy to the market for what precisely they need. But if I could go, Chris, to a broader point that was raised, my take on a lack of regulatory clarity is that it generates litigation, at least here in the U.S. That lack of a real framework, because it isn't unique to Europe. I mean, we don't really have there is no federal law of privacy. It is sectoral, it's really quite spotty, there's state law. It's a bit of a mess here too, just in a different way. And that lack of clarity makes it difficult to operate, even if you were just a US-only company. And what it drives is litigation, because plaintiffs' lawyers live in the cracks and live in...
You sure about it?
I'm on friendly turf here, right? And they live in the gray zone. I mean, the uncertainty and ambiguity is the world they live in, because a class action around consumer rights, around unjust behavior, misrepresentation, these are very squishy terms, and the FTC, with all due respect, Becky, likes to live in the same world. I mean, that's,
absolutely.
They are essentially making law right now via consent decree at the FTC. We are developing a federal law of privacy via what the FTC has chosen to make an issue, sort of consent decree by consent decree.
Yeah. And so, I mean, obviously, you're looking at that and asking what kind of issues are hot. Social media has been, if you look at in the last 2 years, there are about 4 or 5 different cases against a lot of companies that have social media information, either first party, gathering the information and being able to communicate appropriately to consumers, but then other companies who make secondary use of it. And one recent enforcement case against a company that aggregated and sold reports based on collected, allegedly public social media data and what uses they could and couldn't make of that data.
Yeah, I mean, if I can read that far, Kirk's point, I think there is a trickle down to the folks who are using the information. For example, we represent a lot of brands, whether they're retail, financial services, healthcare, companies that have reputations to protect and have brands. And they are getting hit with class actions, not because of anything specific that they've done in the big data market, but rather because of the relationships they have, the company they keep. So something that we're spending a lot of time litigating and then trying to counsel on the front end is be careful of the company you keep, understand who it is you're doing business with, who is operating on your website. Because if you're a brand and it's your reputation out there and you're the gateway to the consumer, you are going to have the FTC or a plaintiff's lawyer show up at your doorstep much more readily than they're going to show up, at the, garage or wherever the data analytics company is being run out of.
And they're going to look at you for responsibility
Correct.
for that, not despite what your contract might say, despite what provisions or protections you might have put out. They're going to look at you from an enforcement perspective.
And that is happening.
This is a great lead into a question that we talked about on the conference call before this. You defend the big corporate customers in website privacy class action cases. Macy's, JCP, Nordstrom, Skype, and others. What are the claims being made, and what can a company do to lower its risk in this sort of case?
Yeah. Well, the current wave of cases over the past 18 months has been around websites and mobile apps, and it's involved local shared objects and flash cookies. That is the sort of, the flavor of the year. Those are the cases we have right now. Those cases are brought in wonderful jurisdictions like Rolla, Missouri, or Fayetteville, Arkansas. They find a friendly state court and they bring a case against typically the brand, not against the vendor. So right now, for example, we're defending a series of cases in Missouri, I'm told. The companies are doing nothing that every retailer isn't doing in terms of just knowing who their customers are, trying to make the experience better for that customer. But they're all using a common vendor. And that vendor is really who is being targeted in this case, but the vendor's not named in the case. It's the brands, because they want the brands insurance, and they know that the brands have a reputation to defend and care about getting sued. So the types of theories, Chris, range from you shouldn't be doing this at all, effectively trying to take the E out of e-commerce. You shouldn't be dropping flash cookies. You shouldn't be using flash. You shouldn't be essentially putting code onto the machine of a visitor to your website. Well, that's saying we shouldn't have an internet, really. That's sort of the nature of the internet. The machines are talking to each other via code. But they're trying to use statutes that have been around since the 1980s, which were designed for really true hackers, computer abuse statutes and computer trespass statutes, to say that by putting code onto the visitor's onto the visitor's server when they visit your website, you effectively have invaded their computer. You have created a computer trespass. So that's sort of theory one. Theory two is, what are you doing with that information? And what's your intent? What's your purpose? Is it merely to help with establishing settings? Is it a settings cookie? Is it a sessions cookie? Something that just allows a better user experience? Or is it meant for tracking? And if tracking, then is there something specifically being done which is considered bad, FTC has come out and said is bad, like respawning, zombie cookies? Okay, so there's certain activities which are considered particularly anti-consumer and high risk. And then, they also ultimately say, well, okay, even if you're doing it, have you told me you're going to do it? Have you disclosed it? Have you told me in plain English that this might happen to me if I visit the website? And just a little tweak on that point, even if somebody does read the 5 pages, if the cookie drops before you can get to the 5 pages, the plaintiff's lawyers take the position that it doesn't matter what's in the 5 pages. It doesn't matter if anybody read it, because the bad thing has already occurred. And then sort of a final twist is, okay, if you can do it at all, and if you're doing it right, and if you told me about it, maybe you ought to be paying me for this information. Who owns it? Talk about monetization. There's going to be a consumer pushback, and you're already starting to see a market develop around consumers controlling their information. So these claims often have an ownership component, totally unestablished as a right in the United States, but often in our system, rights get established via class action litigation. So what they're trying to do is establish, this is my information, and even if you can do something with it, I want a cut. And that's why I think the Facebook IPO was so meaningful, because you started to see figures in the newspaper of, I'm worth $18 a year to Facebook?
Yep.
Well, where's my check?
Yeah.
You know, that's really, to me, the next interesting level in these cases.
We'll definitely come back to that. There's a question down here.
Yeah, as Amy Rasmussen, the CTO of Adobe, who makes Flash.
Yes.
So, and you might imagine I've been following a lot of these cases, and what I've been seeing is that they've been dismissed. A lot of them have been dismissed for companies who are willing to go the distance because the judges are finding there's no harm.
Absolutely, Amy.
And I think I'm following it not because Flash is a good thing, it's what people do with Flash, and it can be misused. I've written papers on it. But what I find frustrating with the plaintiff's counsel is that people are suing, and the judges have consistently been saying, no harm.
Yep.
And unfortunately, class actions just keep coming because people settle before they
It's
get a decision.
absolutely. I mean, the no harm argument is the one we had the good fortune to have some of the first cases in the country in the breach context, and that was the primary defense. And it continues to be a primary defense in these cases involving websites, because that's exactly right. I mean, there is no actual consumer harm. There's an attempt to say that almost import the European concept of a harm to some dignity interest or an invasion of privacy that is somehow unquantifiable. But the classic U.S. court definition of harm clearly does not encompass the sorts of things they're complaining about. And the vast majority of federal cases and state cases have said that and have continued to say that and should. There is tremendous incentive and pressure on companies to settle these cases, sometimes maybe because they have insurance and they're not using their own money, often really because of the reputational issues for getting dragged, through a court proceeding that they'd prefer not to be a part of. But that doesn't make the theories legitimate. It doesn't make the defense any less good. And there are a number of defenses, but that is always sort of the threshold initial defense.
Chris, if I may, this is one of the areas that Reputation.com is. What's your take on the issue of data ownership?
Well, I think whether the litigation is ultimately meritorious or not, it does point to a fundamental question, that there is a tension between consumers and companies as to who owns the data. And I think that there is a feeling by a lot of consumers that information that's collected about them that it was given in a particular context and they've granted rights to, belongs to the companies. But if it goes beyond that, it belongs to them. And I think the Supreme Court case recently involving a tracking device put on a car by, I think it was the FBI in that case, where it was a invasion of privacy case, was very interesting, because what it's ultimately found was FBI agents had put a tracking device in a car, and they were able to track a guy for 28 straight days, knew everywhere he went and exactly what he did. Now, 10 years ago, they could have done the same thing by putting a surveillance team on him and had him tracked for 28 days. But because this was an electronic device put on the car, they found it to be an invasion of his privacy, not because he did it for a day, but somewhere between putting it on his car for a short period of time and 28 days was too much tracking. And it's sort of, in some ways, I still don't quite understand the rationale, and maybe it's going to come back to sort of a pornography thing. You know it when you see it, but at some point between the 0 and the 28 days, it became an invasion of privacy. And now that the law has changed on that issue. And I think that what you're seeing with consumers is they're okay to a certain degree with people tracking their information. But when it gets beyond a certain point, it suddenly becomes information about them, which is far too private that they don't want to know.
Hang on a minute. I've got a mobile phone. That knows where I am 24 hours a day, 365 days a year. Nobody's coming after me for that.
Absolutely. But there are limits on your ability, even within law enforcement now, to access information about your location. And again, I think this is a information that consumers face all the time. Is, you know, we constantly click on things in our phone which allow our geolocation to be used. And I think as consumers become more sensitized to that, maybe that'll become a more informed choice. But I think until it does become an informed choice, there's going to be some level of risk about companies who use that information.
And there's definitely regulatory interest around geolocation,
Okay.
using that data. What do consumers know about it? What do they anticipate? How are you going to use it? And then, you know, so the idea, for example, of serving up ads when you're at a particular location, you know, has always had that little, just a touch of that creep factor. Now, I do think society moves on, and so, you know, if we talked about this a couple years ago, people would be more creeped out about it. Now that apps that use location information have become more mainstream, there's more of a consumer expectation that that information is available. And so I think that over time reduces the regulatory risk.
Well, and is it generational, right?
Yes.
I mean, you know, are the baby boomers making a bunch of laws that our kids are going to laugh at? I mean, will it matter to them in the same way that it matters to us?
I think it's also that that regulators tend to be quite paternalistic, and they assume a certain lack of knowledge among, you know, the populace. So for geolocation, you know, I mean, everybody knows that your mobile is not only transmitting all the time, it's acting as a beacon, so it's collecting data about other Wi-Fis and things around it as well. You know, the average person may or may not know that, and so the regulators are also trying to essentially regulate for that kind of thing.
You can even get apps that will take video from your camera without you knowing. There's a question at the back.
Yes, my name is Rainey Hancock. I represent the firm Legal Shield. Lawyers love the term, or at least justices do, where is the line going to be drawn? It seems to me that we have laws that protect us against other people doing things that we don't want them to do, such as someone who's stalking someone or assault or battery or what have you. But it seems to me also that the consumer is ignorant. They don't know that these things are happening to their computer. I'm afraid that I'm on the plaintiff's side, the attorney's side here. I think one of the solutions would be there should be a warning light that comes on that you can click on yes and allow them to do it, or click no, they cannot do that. Because with all the technology, we're all ignorant. Unless you have a super sensitive and capable internet security program, I think this is a real problem.
I mean, we have that example in Europe right now with the change of the e-privacy directive. You have to have a consent banner for cookies. But no disrespect to Adobe, I mean, cookies are almost dead technology. You know, I mean, cookies are going to be used less and less. You can do digital fingerprinting and things now. You don't need to drop cookies on people's computer. I mean, I just, you know, my issue with the regulations and the way it's being discussed right now is that we have a potential to, you know, I mean, the directive and the OECD principles have lasted for 30 years. We have a potential to do something again, and yet the law tends to be reactive. I mean, the way the new EU regulation is being drafted, it's almost going to be obsolete before it's even promulgated.
Yeah, and why would you then base it on a technology? I mean, because the technology is going to change.
Yeah.
You know, to target this or that type of technology is ridiculous because, as was said, it's, you know, what is done with that technology, you know, and the expectation of the consumer about what's going to be done, you know, not the technology.
Yeah. And so, to my mind, drawing a line in the sand is not really the best way to do it. You know, I mean, technology is iterative. The legislation has to be iterative. It has to be principle-based. It can't be so specific and so granular that it actually stops things from being able to happen. And so, you know, targeting cookies and having consent banners interacts with the user's, the user's experience, and is actually quite off-putting. I don't really see how that actually moves us forward. So I'm sorry.
There's a question over there, sir.
Yeah, so a lot of interesting discussion and a lot of things focusing on security and privacy and regulation are interesting, but I'd like to kind of bring the folks back to the big big data, which is going to be Bill was talking about. Businesses kind of build based on big data and how to utilize, right? That's kind of what has happened over the last 10 years. And somebody mentioned that consumers are ignorant to some extent, which is true. I'd like to give an example of, an extreme example, like Foursquares, right? I think it kind of sends the information about where the people are going. So people go up and sign up for it without knowing what the main purpose of the application is. And they know of a case where somebody got fired because they are not at work, because they're visiting malls during work hours, and information was being posted to the social network.
Sure.
So this is how
Sure.
stupid it can get, right? So there is a lot of ignorance with consumers, because in the old days, technology was used by other technology people, right? Now it is actually directed to everybody. So there is some amount of education, I believe, needs to happen on the consumer side, whether it's businesses or not, because business is making money using data. I mean, otherwise businesses don't exist today, right? So that is point number one. Point number two is, if somebody shares information because they get a good deal, I think in the last panel somebody said that, it's true. But then somebody, whether legally or illegally, kind of shares that information, and then you get an email with an offer. If you go ahead and accept it, right, and go ahead and buy something, you're basically kind of perpetuating this thing more, right? So you're at fault too, and a lot of us actually do that, right? You may say that, but then you get a good deal, and you don't care how it got. Well, I want the deal, right? So it's like the saying goes, if you make a law and you cannot enforce it, it's no law, right? So there's a lot of education that needs to happen rather than just saying, just do regulation, because technology is changing, business is changing, data is business. So otherwise you can shut the business and go home, right? I mean, nobody's going to make money with education. So I don't know what your perspective is on the education part, both for the businesses and the consumers, rather than taking a big hammer and saying regulate.
So that actually goes right into one of the points of, that the FTC was focused on in its privacy report. It said, look, consumers don't know what's happening to the data. They don't know when they make that choice what implications it has. So, we need to talk as an industry as to what's the way to communicate that simply, but without putting off consumers, right? We don't want to say, don't give us your data because we're going to give it to everybody else. That's not what we mean. We need to communicate their benefits to that, and I think that can be done. We've all got great marketing people. The same people can be employed, the plain language people as well, the PhDs, to tell consumers, here's what's going to happen with your data, and it's a good thing because you're going to get that deal and you're going to get that. And I've seen some companies doing this very successfully about saying, sign up with us, or much more of a consent-based model, but sign up with us and we're going to use your information and we may share it with other people to get you even better deals. Does that carry the day? I don't know, but again, I think it's just an issue of being able to interact with consumers and figure out where their pain points are, where that ick factor starts to come in.
Yeah, I don't know if it carries the day, but it sure makes my job a lot easier to help you if you're facing the FTC or you're facing a judge and explaining the measures by which the company attempted to make this clear and that the industry has used. And I think it's worth the investment. My perspective on this is I come from the consumer class action defense industry. Before this issue, it was and still is, mortgages, credit cards, fights around those industries. The same fights. Did consumers understand the mortgage that they were taking out? I mean, that's what the litigation over the last 4 to 5 years has been about. How much easier would it have been for the financial industry to be defending these cases right now if there had been a serious effort at consumer education at the front end?
I think there's also technology that can help with this, and certainly, I think Reputation.com is one such company, but I think, there's initiatives in various governments as well. Kenya is doing something called My Data, UK is doing something called My Data and Open Data, and I think there's essentially a market for individuals to become their own data brokers, and for companies to essentially, help individuals understand what data is out there about themselves beyond that bilateral relationship. Going back to the car example, how many people know there's so many sensors in cars about who's sitting in a seat that essentially controls an airbag if you're in an accident? Going back to Splunk, My washing machine can communicate with my smart TV to help me reduce my environmental impact in my house. I think ultimately, if people understand how the data is being used, they won't find it scary, they will find it helpful. And so industry has a role in also educating individuals. The negative example is the example of Target, where the teenagers' shopping habits were essentially aggregated, and she received coupons about baby products and things. And the father went ballistic when he found this stuff, and this was the first opportunity to tell the parents. That's one bad example, but it gets bandied about quite a lot. There's lots of good examples where people benefit from data use, and they actually like being targeted. As we heard from the panel before, they like the advert that is very targeted to what they're interested in and what they want to do, and it may actually increase the potential to buy that product, whatever it may be. So, I think companies like Reputation.com, other companies where essentially they're helping people become their own data brokers in a way that is not a hassle for an individual.
I think that's true. I mean, our business in some ways is about online control. We all have an online reputation, good or bad, minimal or large. And what people want to do is be able to control what that is and say what they believe is the truthful and the things that represent them, as opposed to maybe negative content. The same thing is true with the information that's being collected about us. One of the questions we talked about in our call was this right to what's the phrase? Right to be forgotten.
Yes.
Well, that's unrealistic in today's age. I mean, everybody's collecting information about you, whether it's your healthcare provider, your insurer, every transaction you do online, someone's collecting information. You are not going to be forgotten. But that doesn't mean you don't have some level of control about it. And one of the ways we try to help people is we have relationships, either technical or commercial, with data aggregators who buy and sell your personal information, and have ways in which we can have that information taken off their websites. I mean, I think one thing that the FTC has always been very favorable towards businesses is if they give the opt-out requirement. I mean, we have this do not call list for telecommunications. If you put your name on do not call, you now cannot be called. We have possibility of do not track legislation. Well, if there are technical solutions like the kind we offer, which essentially give people a do not track, do not call right, and opt out from the collection of your information, I think that goes a long ways towards toward giving people the level of control that keeps them out of trouble.
Okay.
And the possibility is your company offers a sort of a do not track option with respect to their spending habits. It may diminish the ability of you to mine your own information, but may give you some protections that you need. And frankly, there's so much information out there that the deletion of a little bit of that information is probably not going to be harmful to the overall enterprise.
Okay. We've got time for one last question. Before I get to that, I was asked to make the point to the attorneys in the room. And not only has this been a very interesting and an enlightening panel, it's also, you can use it as 1 hour of CLE credit, whatever that means. So it's all good for you too. So, 1 hour of CLE credit. Yes, ma'am, question.
So the comments about privacy regulations, I think for the most part have been directed at the harvesting of adult-related data. Can you comment on, both for the US and the EU, how do things change when the target of the harvest is children, child-related data, and maybe also comment on, is any kind of paternalistic regulation ridiculous in a world where my 11-year-old is probably more facile with settings than I am?
Europe doesn't regulate children separately. And that's kind of the problem with, I think, the existing European regulation. Personal data the definition is massively broad. It's any information that identifies directly or indirectly a living individual, regardless of age.
So in my contrast, of course, the United States focuses on 13 and under, 13 being the magic age. My son would have argued it should have been 12. He was lobbying for a Facebook page long before he was allowed to have one. And a lot of them are more sophisticated. And frankly, there are some teenagers who are around 15 who should frankly need these protections. But the focus has been on that. There's a lot of attention on whether that regime, COPPA is the name of the act that covers this, needs to be expanded. to cover mobile phones, and there have been some enforcement actions sort of taking what has been an internet-based law and stretching it to apply to the mobile community. So they're looking for ways to take the existing laws and extend those protections beyond that, recognizing that kids are now operating in this mobile phone handheld
I thought
area.
I had seen something like an FTC enforcement action against a fan site. It seemed very specific.
Yeah, so it was focused on a music site, and it actually went after the company and a couple other affiliates along with that. They were, getting information from children, knew there was for children or didn't have, enough information to weed them out, and using that to target other advertisements to them. So, there's supposed to be this mechanism for opt-out, but it's challenging for a consumer because many of my son's friends all had Facebook page. They just lied about their age. So what's a company to do, right? If they're saying, I'm not going to knowingly establish a relationship with a person under this age, but, we have a lot of technology out there that kids are accessing regardless of these restrictions.
It goes back to sort of the fundamental consent-based notion of using personal information, which is you can't get informed consent from a minor. So if the model changes some other direction, maybe there's a way in which that model changes. But as long as I think the notion is that a child cannot consent, why it's 13 in some areas and older in others, I'm not sure, but as long as it's a contract-based sort of analysis, I think that's going to stay in place here in the U.S.
Yeah, and the same in Europe. I mean, the draft data protection regulation that's making its way through the European Parliament right now has followed the rights of the child treaty out of the UN and has set the bar at 18. But at this point, age is not regulated in a way different from any adult.
Okay, we have time for one very last quick question.
Actually, just a quick comment. Steve Dowdy with Smarts Inc. A year ago, I was with Yahoo, and I wanted to echo the comment that you were making about educating users. And one of the things that Yahoo did was it actually converted the permissions of Yahoo Mail users from "we won't look at your email information" and to "you are going to allow us to scan your emails." And we were very, very explicit, and that's kind of counterintuitive, right? You'd sort of almost be tempted to try to sneak it in with a pre-checked button or something like that. But we took the opposite approach, was to say, here's exactly what we're going to do. Here's exactly what we're going to get access to. In big letters, it wasn't even fine print. And here's what we think the benefits are. And we were able to convert 93% of the users over out of a base of 300 million. So it actually does work. And I would encourage anybody who wants to, look at changing the permissions of a large user base to be more disclosing than you might actually intuitively think you should be, because people will opt in.
Okay, terrific.
That actually raises another issue, which I think is interesting, which a lot of people probably aren't aware of. Where you're opening, it's a debate in Europe, which is contrary to the anti-interception laws. So if you're doing any kind of deep packet security where you actually can see content, or the change in the Yahoo Mail where you can actually see content, it's actually contrary to the interception laws in Europe, according to some pundits.
Okay.
So.
Unfortunately, we're out of time. There's obviously a lot more we could go into, but I'd like to please join me in giving the terrific panel a round of applause. Thank you. Thank you.